A federal court ruling released in December quietly changed the rules of gun ownership across the United States. Most firearm owners still have no idea this decision even exists. While the media barely mentioned it, 10 sweeping legal changes went into effect almost overnight. These changes strengthen gun rights in ways that have not happened in generations. The final change alone is shocking, because people were being arrested and threatened with years in prison for the exact same actions just weeks before this ruling. This is not political speculation or future theory. These are active legal changes already reshaping how gun laws are enforced. Failing to understand them could put you at serious legal risk, even if you believe you are obeying the law. That is why this information matters, and why every gun owner needs to hear it. Law 1 is the Supreme Court Protection Standard. This is the most important shift in Second Amendment protection in more than 50 years. Everything else that follows is built on this single decision. The highest court in the country ruled that the right to keep and bear arms must receive the same strongest level of constitutional protection as freedom of speech and freedom of religion. That sounds simple, but the impact is enormous. Before this ruling, lawmakers could pass gun control laws and courts would usually approve them as long as they appeared reasonable. Judges applied flexible standards that gave governments wide latitude to regulate firearms. That framework is now gone. From this point forward, any law or regulation that limits gun ownership or carrying must pass the strictest legal test available in the American justice system. Instead of gun owners having to explain why they need firearms, the burden has completely flipped. The government must now explain why it believes it has the authority to restrict a constitutional right. To meet this standard, officials must satisfy two major requirements. First, they must show an exceptionally compelling reason, not vague claims about public safety or generalized fear. Second, even if such a reason exists, they must use the least restrictive method possible. If a law limits more freedom than necessary, it fails. Legal scholars estimate that more than 500 existing federal firearm regulations are now vulnerable to being struck down because they cannot meet this new standard. Laws that survived for decades under weaker scrutiny are suddenly on unstable ground. This single ruling has opened the door to the largest wave of gun rights challenges in modern history. Law 2 establishes real police accountability for Second Amendment violations. For decades, police officers operated behind a legal shield known as qualified immunity. This shield protected officers from lawsuits even when constitutional rights were clearly violated. When officers arrested lawful carriers, confiscated firearms without cause, or ignored gun rights entirely, victims were often left with no realistic way to hold them accountable. That protection has now been severely weakened. Officers who violate firearm rights can be sued personally, meaning their own finances are on the line. In addition to civil lawsuits, officers may now face federal criminal charges and permanent removal from law enforcement. This is not hypothetical. In Arizona, 2 officers were ordered to personally pay $1.9 million after detaining and arresting a woman who was legally carrying with a valid permit and breaking no laws. In Georgia, an officer lost his retirement pension and faced federal charges after seizing firearms during a traffic stop without any legal justification to search the vehicle. Police departments across the country are now issuing internal warnings. Officers are being told directly that interfering with lawful gun ownership can result in career termination, financial ruin, and criminal prosecution. This ruling did not just change laws, it changed incentives. Law 3 is the firearm confiscation ban without due process. Government officials can no longer seize firearms unless full criminal justice procedures are followed. Red flag confiscations based solely on accusations have been ruled unconstitutional. Before this ruling, a single phone call could destroy someone's life. A neighbor involved in a dispute or a bitter former partner could contact police and claim concern. Officers would arrive, confiscate every firearm in the home, and leave the owner fighting months or even years in court to recover their property. During that time, no crime may have been committed and no charges filed. The December ruling put an end to that practice. Firearms cannot be taken unless an arrest occurs. Prosecutors must file formal criminal charges. The owner must receive full due process, including the right to a fair trial. Law enforcement agencies had been using vague claims of potential criminal connection to justify firearm seizures. Even when owners had clean records, and were never charged with any offense. Official records show that more than 15,000 firearms were taken using these methods over the past several years. Many owners gave up trying to recover their property because legal costs exceeded the value of the firearms. Anyone whose firearms were seized under red flag orders or civil asset forfeiture within the last 5 years can now file for immediate return. The government is legally required to comply. Law 4 eliminates the federal gun owner database. The federal government has 90 days to permanently delete all digital firearm ownership records. This ruling represents one of the most significant privacy victories in decades. Although federal law explicitly forbids the creation of a national gun registry, the ATF quietly built a massive searchable database anyway. Over 1 billion firearm purchase records were digitized and stored. Agents could search by name, address, or firearm model in seconds. Several states quietly shared gun owner data with federal agencies through undisclosed agreements that were never approved by voters or legislators. The court has now ordered certified proof that every digital record is permanently destroyed from all systems. If agencies fail to meet the deadline or refuse compliance, they face contempt of court charges. Individual officials responsible for maintaining the databases could also face criminal penalties. The background check system has received similar orders and must now erase approval records immediately instead of storing them indefinitely. Law 5 establishes a clear prohibition on warrantless digital surveillance of gun owners. From this point forward, any government agency that wants to monitor firearm-related activity must first obtain a warrant signed by a judge. For years, federal agencies tracked lawful gun owners without court approval, without suspicion of a crime, and without notifying the people being watched. Agencies collected cell phone location data to see which gun stores people visited. They monitored online purchases of firearm accessories through credit card records. They tracked search histories related to ammunition, gun modifications, and carry laws. Entire digital profiles were built on citizens whose only action was exercising a constitutional right. The court made a direct statement that owning firearms is not suspicious behavior. Simply exercising a protected right does not give the government permission to spy. Digital data connected to firearms is now protected in the same way as private communications, religious activity, or political speech. A classified surveillance program that automatically placed people on watch lists for searching firearm-related topics has been completely shut down. When any agency wants access to digital information tied to gun ownership, it must now prove probable cause that a specific crime has been committed. Fishing expeditions are no longer allowed. More than 60,000 gun owners were actively monitored under these programs without their knowledge. Many of those individuals are now pursuing legal action. Early settlement offers in these cases are averaging around $50,000 per person, and additional lawsuits are still being filed. Law 6 reforms concealed carry permits across all 50 states. The process to obtain a permit is now faster, cheaper, and standardized nationwide. The court imposed 3 mandatory rules that states must follow immediately. First, permit applications must be fully processed within 30 days. There are no extensions, no exceptions, and no administrative delays allowed. If the deadline is missed, the permit is automatically approved by law. Second, states are no longer allowed to require applicants to prove good cause or special need. You do not need to explain why your life is worth protecting. The desire for lawful self-defense is sufficient. Third, total application fees cannot exceed $50. States are prohibited from adding extra charges, training surcharges, or hidden processing fees. Before this ruling, some states deliberately used long delays and high costs to discourage applications. Massachusetts routinely took 10 to 18 months to process permits. Illinois charged combined fees exceeding $400. These practices are now illegal. Tens of thousands of permit applications that sat in government offices longer than 30 days are now considered approved. In Rhode Island, where only a few hundred permits had been issued statewide, authorities were forced to approve thousands of applications within weeks of the ruling. However, a permit alone is meaningless if you cannot purchase ammunition. Law 7 removes ammunition restrictions nationwide. Ammunition purchases are now treated like any other lawful retail transaction. States no longer have authority to impose special regulations on ammunition that do not apply to ordinary consumer goods. Illinois previously required a full background check for every ammunition purchase, even for a single box. That system has been eliminated. Massachusetts banned online ammunition sales and home delivery, forcing residents to travel hours to find supplies. Those bans are now void. Some states imposed limits on how much ammunition a person could buy in one transaction and maintained records of buyers who purchased larger quantities. Those restrictions have also been struck down. The court recognized a basic reality. A firearm without ammunition is functionally useless. Treating ammunition as a prohibited substance while allowing firearms themselves made no legal or logical sense. In a single year, Illinois conducted more than 5 million ammunition background checks, costing lawful citizens time and money without measurable public safety benefits. Retailers can now sell ammunition without special reporting requirements. Online sellers can ship across state lines without additional licenses. There is no legal limit on how much ammunition can be purchased in one transaction. These changes immediately increased supply and reduced prices. Online ammunition retailers report sales increases exceeding 400% in states that previously restricted shipments. Law 8 strengthens protections for federal firearms license holders. Gun dealers now receive the same legal protections as any other lawful business in America. For years, the ATF used aggressive enforcement tactics to shut down gun shops over minor paperwork errors unrelated to criminal conduct. Errors such as unclear handwriting, incorrect formatting, or small clerical mistakes were treated as grounds for license revocation. Entire livelihoods were destroyed without any allegation of criminal activity. That practice is now prohibited. The ATF may only revoke a federal firearms license for actual criminal violations. Clerical mistakes, administrative errors, and formatting issues are no longer valid reasons for shutting down a business. FFL applications must now be processed within 60 days. If the agency fails to act within that window, the license is automatically approved. This rule applies nationwide with no exceptions. Home-based gun dealers who were previously targeted by zoning boards now have federal protection. Cities and counties are prohibited from using zoning laws to block federally licensed dealers from operating legally out of their homes. Over the past year, the ATF revoked 148 licenses solely for paperwork issues with no criminal allegations. Since the ruling, new FFL applications have increased by nearly 100% as fear of arbitrary enforcement fades. Law 9 prevents warrantless firearm-related searches. Government agents no longer have authority to enter homes or private property to inspect firearms without a warrant. Surprise inspections are now illegal. ATF agents previously conducted unannounced visits to collectors, home-based dealers, and small businesses, demanding immediate access to firearms and records. Refusal often resulted in threats of license revocation or investigation. The court reaffirmed that the Fourth Amendment protects the home. Firearm ownership does not reduce that protection. Before any search or inspection related to firearms can occur, agents must obtain a warrant signed by a judge that lists specific criminal allegations. These protections apply equally to private collectors, shooting ranges, retail gun stores, and firearm-related businesses. Over the last 4 years, more than 3,000 warrantless inspections were conducted. Lawsuits are now being filed, with settlements averaging $85,000 per case. Law 10 secures cross-state travel rights for gun owners. This change affects more people in daily life than almost any other because millions of Americans travel regularly for work, family obligations, emergencies, or vacations. For decades, gun owners lived with constant fear when driving through states with restrictive firearm laws. People were arrested during routine traffic stops while simply passing through a state they never intended to stay in. Firearms that were legally owned, legally purchased, and legally stored were suddenly treated as felony weapons depending on the state line they crossed. Lives were turned upside down over technicalities. Under the new federal protection, traveling with a firearm is fully legal as long as the firearm is legal in the state where the trip begins and legal in the state where the trip ends. This protection applies for the entire journey in between, regardless of which states are crossed. You are now legally allowed to stop for gas, eat meals at restaurants, check into hotels, and stay overnight without risking arrest or prosecution. Temporary stops do not break protection. Normal travel activities do not expose you to criminal charges. In Maryland alone, more than 1,000 people were arrested over a 6-year period for possessing firearms while driving through the state to another destination. Those individuals were not committing violent crimes. Many were simply families traveling or workers commuting. Courts are now dismissing every one of those cases and expunging them from criminal records. In Connecticut, one man was charged with criminal weapons possession after a state trooper discovered his legally owned pistol locked in a secure case in his trunk during a traffic stop for a broken tail light. He spent nearly 3 years fighting the charge and paid over $50,000 in legal fees before the case was dismissed. Under the new federal protection, cases like this are no longer possible. When stopped by law enforcement while traveling with a firearm, there is a specific phrase that matters. You should clearly state that you are traveling under federal interstate protection laws. This establishes your legal standing immediately and places officers on notice. These protections are not theoretical. Courts across the country are already enforcing them. Arrests are being overturned. Charges are being dismissed. Records are being cleared. The legal risk that once followed gun owners across state lines has been dramatically reduced. Together, these 10 changes represent the strongest expansion of Second Amendment protections in modern American history. This is not a small adjustment or a temporary policy shift. It is a structural change in how firearm rights are viewed, enforced, and defended under the law. Gun ownership is now held to the same constitutional standard as speech, religion, and due process. Police officers face personal consequences for violating firearm rights. Firearms can no longer be confiscated without criminal charges and full legal proceedings. Gun owner databases are being erased. Digital surveillance without warrants has been shut down. Concealed carry permits must be processed quickly and affordably. Ammunition purchases are no longer treated as suspicious behavior. Gun dealers are protected from arbitrary enforcement. Homes are shielded from warrantless inspections. Travelers are protected across state lines. However, there is a hard truth that needs to be said clearly. None of these protections matter if you do not understand them. Rights only work when they are known, asserted, and exercised correctly. Ignorance does not protect you. Silence does not protect you. Assuming the system will automatically respect your rights does not protect you. Law enforcement agencies, government offices, and regulatory bodies are still adjusting to these changes. Mistakes will happen. Overreach will still occur. The difference now is that the law is on your side if you know how to respond. That is why staying informed matters. That is why understanding the exact language and limits of these protections matters. And that is why sharing this information matters. If you own firearms, this information affects you directly. If your friends or family own firearms, it affects them as well. Many people are still living under outdated assumptions about the law that no longer apply. Subscribe and turn on notifications so you stay updated as these rulings continue to be enforced and clarified. Legal challenges are ongoing, and additional protections may follow. Missing these updates could expose you to unnecessary legal risk. Share this with others who own firearms, not to create fear, but to create awareness. These rights exist now. They are real, but they only protect those who understand how to use them. Your constitutional protections have never been stronger in your lifetime. Make sure you know them, make sure you assert them, and make sure you never give them up by accident.